Ready? Shorthand legal dictation. Start. We have heard learned counsel for the parties. Full stop. Main contention raised on behalf of the state of Uttar Pradesh is that while it was permissible for the central government to lay down eligibility qualifications for appointment of a teacher for elementary education by virtue of section 23 of the RTE Act, the NCTE could not lay down any guideline so as to affect the power of a state to prescribe norms for selection of a teacher consistent with the qualifications under section 23 of the RTE Act, full stop, para 13 dot. On the other hand, the stand of the original writ petitioners is that the subject of education falls under entry 25 of list 3rd of 7th schedule of the Constitution after the 42nd amendment, full stop. Thus, by virtue of Article 254 of the Constitution, the law made by the Parliament prevails over any law made by the state, full stop. It was submitted that the NCTE Act has been enacted by the Parliament to achieve code, planned and coordinated development of the teacher education system, full stop, unquote, para. The council constituted under the Act is empowered to issue guidelines under sections 12 and 12 capital A for ensuring planned and coordinated development of teacher education and also to lay down guidelines in respect of minimum qualifications for a person to be employed as a teacher, full stop. Further, 17 YD notification dated 31st March, 210 under section 23 of the RTE Act, the central government has authorized the NCTE as an code academic authority, unquote, to lay down minimum qualifications for a person to be eligible for appointment as a teacher, full stop, para 14 dot. Learned counsel for the NCTE submitted that notification dated 11th February, 2011 suggesting weightage to TET marks was merely a guideline and was not intended to be binding on the states, full stop. While TET was a mandatory requirement, weightage to the marks in the TET was merely a suggestion, full stop, para. This stand has also been taken by some of the learned counsel in connected matters, Reliance was placed on the stand of the NCTE in its affidavit dated 1st May, 2014 in CWP 346 of 2013 before the Punjab and Haryana High Court as follows: code that in view of the said recommendations of the committee, it is stated that the guidelines contained in clause 10 and 11 of NCTE guidelines dated 11th February, 2011 are directory in nature, full stop. Appropriate government may in its own wisdom decide as to the eligible candidates on the basis of having qualified the central teachers eligibility test, full stop, para. However, education being the subject matter of concurrent list of the power to frame appropriate legislation, regulations, rules, works with the appropriate legislature of the state government, and as such, state government is well within its rights to prescribe the qualification of eligibility in the form that the candidates wanting to apply for the said post must necessarily qualify the teacher's eligibility test of said state, full stop. There would be no legality in the same, and merely because a state government had failed to conduct the state teacher's eligibility test in bracket STET bracket close in a given year would not amount to taking a decision not to hold the exams and to hold the candidates having qualified central teacher eligibility test as eligible, full stop, unquote. Stop.